So let's start. Hi everyone, good afternoon. Thank you for your presence. I'm very pleased to facilitate the discussion today on this very intriguing topic, antitrust in sports. So the sports industry is of substantial economic relevance, moving approximately $500 billion worldwide, and in Brazil it accounts for around 2% of the GDP. Its significance doesn't come solely from its entertainment role, but also from, for instance, from the other business that derives from it and its impact on culture or on the population's health. And sports rely on competition, but controversially, the industry wouldn't exist without collusion, which complicates its treatment in competition law since it legitimizes a range of cartel-like agreements. So today we'll discuss exclusive deals in broadcasting rights, sports betting and the need of regulation, antitrust exemptions and its issues, and SAFs in soccer, and other recent cases that expose the many complexities of competition in this industry, nationally and internationally. And to enlighten us in all of this, we have this excellent panel that I'll now introduce. So Dr. Maria Garibotti, that is online, holds a PhD degree in economics from NYU and a bachelor's degree in economics from the Universidade de San Andrés. She is vice president at Analysis Group, and in her antitrust work, Dr. Garibotti has evaluated market definition, market structure, competitive effects, and efficiencies in merger reviews and investigations, and has assessed the appropriateness of class certification. She has evaluated allegations of collusive behavior, refusal to deal, exclusive selling arrangements, and non-compete clauses in litigation. Mariana Chamelette holds a holds a bachelor's degree in law from Universidade Presbiteriana Mackenzie. She is vice president at the Brazilian Sports Law Institute and prosecutor at the Sports Justice Tribunal for Soccer in São Paulo, the Sports Anti-Doping Justice Tribunal, and the Sports Justice Tribunal for the National Futsal League. She is also an auditor at the Superior Volleyball Justice Tribunal and serves as the Attorney General at the Superior Judo Justice Tribunal. Additionally, Mariana is a professor of sports law and extension and postgraduate courses and partner at Chamelette Advocacia. Luciana Martorano holds a master's degree in commercial law from USP and bachelor's degree in law from Universidade Presbiteriana Mackenzie, and is currently specializing in gender analytics at Toronto University. Luciana is a partner at Campus Melo Advogados in cooperation with DLA Piper of the Antitrust and Competition Practices based in São Paulo. And finally, Diogo Thomson de Andrade holds a master's degree in philosophy of law and a bachelor's degree in law, both from PUC São Paulo. He has been a federal prosecutor since 2004. And since 2012, he has held the position of deputy superintendent of CADE and served as acting superintendent general of CADE between July and October 2017. He has professional and academic experience in the field of law, with emphasis on law and economics, philosophy of law, constitutional law, civil and criminal procedure law, and administrative law. So let's begin the discussion with broadcasting rights. This part of the industry has significant impact on revenue distribution and competition dynamism. And here in Brazil, we had the emblematic case of the Club of 13, in which in October 2010, CADE eliminated Rede Globo's right of first refusal in the negotiation for the television rights of Brazilian Soccer Championship, aka Brasileirão. And in merger control cases, we had the Disney-Fox merger in 2019, which impacted the market for basic sports channels in pay TV due to the combination of ESPN and Fox Sports. So, Diogo, can you talk about these precedents and how CADE handled these peculiarities in competitive dynamics in this market?
Sure. I will just briefly switch for Portuguese. I request permission for Maria to do this, just to thank the organization. Eu queria, em nome do CADE, em meu nome, agradecer pelo convite. É uma honra para mim estar aqui nesse evento do WIA. É uma entidade que já tem se tornado tão importante e trazendo um tema tão importante, tão caro e tão necessário para a discussão também dentro do Antitruste, não só no Antitruste, mas no mundo. Queria parabenizar a organização, dizer que esse evento já é parte do calendário anual dos eventos Antitruste, mas mais do que isso, o que a gente ouviu da repercussão do painel do dia de hoje de manhã e do último painel. Acho que ele cumpre demais o seu evento. É até difícil falar de coisas estritamente técnicas e depois de painéis tão inspiradores. Eu acho que esse é o papel desse evento, além de discutir aquilo que está na vanguarda do Antitruste. Por isso eu parabenizo novamente a organização e agradeço o convite. Now I will turn to English again. Answering to your question, the Club of 13, it's an emblematic case of the Antitrust Authority, and it's a very important precedent. And I think both cases, Club of 13 and Disney Fox, bring to us many elements that will be important and of more and more importance in the near future, given the upcoming importance of the new formats of competition, mostly in football in Brazil and around the world too. The Club of 13, some of you from the audience weren't even born when the case started in 1997. I was at Quer at the time, so I'm a little. it shows me it shows you my age, and the case was a very complex case because it deals with different issues of antitrust. So we have a cartel discussion. It was a cartel complaint against the clubs, the 13 clubs. They were the most important clubs in Brazil, and they are negotiating their rights of broadcasting together. So it seems like a cartel for antitrust glasses. There also was a discussion about a JV that Globo and Bandeirantes had at the time for the broadcasting of the Brazilian Serie A of the championship, and also within this relationship between clubs and the broadcasting and Globo, there were some discussion about exclusive dealing clauses and rights of preference clauses. So the case has this broad scenario of different issues.
Recording in progress.
And antitrust. Now we're starting to record. But it has to be interpreted. Thinking about the case that was judged in the early 2000s or in the late 2000, but it was a case that began in the late 90s. So in that time in Brazil, the Brazilian Soccer Championship was only broadcasted by Open TV, and so Globo, who has the rights to broadcast this championship, it was a monopolist in this sector. So we are dealing with a monopolist on one side and a group of clubs that had some market power, so to say, because they are the most important clubs in the other side. This was the complexity of the case, but the precedent is still useful for today because at that time CADES states some points that are very important to the discussion of the broadcasting rights until today. So, for example, looking for the cartel part of the case, at the time we had the Pelé's law, Lei Pelé, and the Pelé's law said that both teams are the owners of the rights of broadcasting their game. So it has to be some cooperation between the two clubs that are playing against each other in order to even have the broadcast. So what CADE understood is that this kind of cooperation was possible. It was not an antitrust infringement, and even more that the type of negotiation should be. CADE should allow some kinds of collective bargaining and collective negotiations for this right, because this was more efficient to the type of the so-called product that we are dealing with. And the other thing is regarding the JV with Globo and Bandeirantes, CADE decided that sublicensing the rights. It was a good thing for competition because, and for even more for consumer, because you have more than one vehicle broadcasting the games. So the point of the CADE's decision was the most important part was regarding the exclusivity and the preference clauses. regarding the preference clauses, that was the real point of matter, because these preference clauses allows Globo to keep this monopoly until after the terms of the contract. So anytime there is a new bid for broadcasting the rights, Globo could cover the offer from the offer from another entrant, and then keep the rights with them. So at the end, CADE decided that this preference clauses should be banned, and then after the termination of the current contracts at the time in 2019, we changed for a situation of monopoly to a situation that Globo still has dominance. And it's not a coincidence that we have another investigation of abuse of dominance that is started right after the end of the monopoly. But it was not more a case that we are dealing with totally blocking the entrance of a new competitor, but dealing with a more antitrust-like remedies about anti-competitive behavior. So our new investigation about that is about the broadcasting rights. It's against Globo, and some possible conducts regarding the Globo tries to keep this position, this dominant position, use the new scenario of broadcasting rights, which is an open scenario for competition, and also an open scenario for competition between media, which was a feature that doesn't exist in the past. In the other case, Disney Fox, the broadcasting rights was also the main issue of the case, because there was more horizontal concentration between Disney, who owns ESPN, and Fox in this business of broadcasting events of sports events. And in this case of Disney Fox, it was not only a matter of behavior, but a matter of structure. We are going from 4 players to 3, or 3 to 2, depends if you consider one of them a player or not, one of the others a player or an efficient rival or not. And in this case, what CADE decided was that it would be good for consumer and for keep the competition open if we keep at least one more channel than Disney, Fox together, and Globo, which was the owner of the other pay TV channel. So we tried to create a remedy that ESPN would sell Fox with everything that Fox represents in Brazil: brand, employers, and of course distribution and broadcasting rights. The case is was not a buyer. There was not a buyer for this company, this new company, and then CADE has to change it a little bit, these remedies for behavioral remedies regarding broadcasting rights. So in order to protect consumers during some time, to be precise, until the last session of CADE, ESPN needed to keep Fox alive and broadcasting the events that Fox already have before the merger. So I think this is an overview, but it shows the importance of broadcasting rights when we are discussing this market. I can foresee more complexity in the future. Because we at least what we learned from the news is that the main clubs in Brazil are again trying to create collective entities to negotiate broadcasting rights, or even to create a one league to organize the Brazilian Serie A championship. So it may be old precedent when we talk about Club of 13, but it's a milestone, and it's still useful for that discussion that is ongoing.
Thank you, Diogo. And Maria, from an economic standpoint, how do you evaluate the effect of exclusive broadcasting deals on competition in sports market. Are there efficiency gains that justify this practice?
Yeah, thank you. And I can't switch to Portuguese because I understand, but I can't speak it. But I wanted to thank you, Luciana, for organizing this panel, and to Women in Antitrust for hosting this event. And generally to all of you and everyone in the audience for accepting an Argentinian speaking about sports in Brazil. I really appreciate the invitation. So, you know, and I should say, I'm sure this applies to all of you, but these are my thoughts, and they're not my employer's thoughts. They're not analysis group's thoughts in everything that I'm going to say. So about exclusive broadcasting rights, like you said, Luciana, this is a very important antitrust question. And different leagues and sports are going to have different economics on how to analyze the broadcasting rights. And I want to kind of give an overview of how an economist would think about this. And part of it, I'm going to punt to the next, to a later topic. So, you know, when we think about creating intellectual property, we actually tend to think that it's generally okay for creators to choose how those rights, the rights to their intellectual property, are going to be distributed. So I don't know if Bluey has made it to Brazil, but I know that when the BBC decides who to license the rights to Bluey, it doesn't need to give it to multiple channels, right? It can decide that it's going to be exclusively broadcast in one network or another. And that's because generally we think that we want to encourage creators to create something interesting for society at large to enjoy and for consumers to enjoy. And so we tend to think that if we give them money, or if we allow them to choose how to distribute their product, they're going to create something that's interesting. And so what is different about sports? Well, like you said, it's huge. And it's huge economically, and it's also huge culturally. And so when we try to think about what are the questions that an economist would ask about sports, first we have what we've hinted at, right? Is like, if you have a league or multiple teams that are licensing their rights to their games together, is that collusion? Is that a cartel? Or is it something else? And so that's what I would call a horizontal question. And I think we're going to come back to that a bit later, but you know, we'll see if I have time. I could speak out this for hours, right? So I'm going to try and focus. But then the question is, can they license them exclusively to a single media company, right? So it's exclusive to just one. And relatedly, can they license all rights? So rights to over-the-air TV, to pay TV, to mobile, or to the internet rights, all to the same company, or does it make sense to license them separately? And so that is what I would call the vertical component. And I think that's what's most interesting about broadcasting rights in particular. So I'm going to start there. So if we assume for now that it's okay for clubs to cooperate and license their rights together, then, you know, the main value or efficiency of licensing rights together is that they get an income stream from it, which is very, very significant lately. And that allows them to invest in the sport, right? So it allows them to retain players. I'm sure that in Brazil, there's the same problem as in Argentina. Everyone goes to Europe, right? So we want to give the clubs money to retain players for as long as possible. We want them to invest in their stadiums. We want to have funds to maybe promote smaller teams, not just the largest teams. And so it, to some extent, creating the largest amount of funds going to the clubs that create the product is itself something that I would call pro-competitive as an economist, or maybe like an efficiency, a gain that comes from having an exclusive license, because it tends to allow for higher payments from the broadcasters. It can also allow you to have kind of non-monetary gains. So if you have an exclusive license, it may be easier to obtain quality assurances from the broadcasters. So you want them to invest in technology to make the broadcast better. Or it can allow you to, for example, have the condition that you have to broadcast a large number of matches and not just the most popular matches. And so exclusivity increases the value. Some of these constraints reduce the value, but overall it allows for the league to have more control over how to promote its sport, and how to make it best for the consumers of that sport, which is ultimately what we think is their goal as economic agents. So that would be one of the main benefits of having exclusive rights. But at the same time, I do want to kind of focus on other aspects of it. The reason why we think it may be a problem to give them all to the same company is that we think, I think especially, I was born certainly in 1997, but if you go back to 1997, you think about sports and they can be the real anchor for a network, right? Like you go there to watch a football game and then you stay for other programming, or you see advertising for other programming on that network, and it gives it an edge over its competitors. And so when we think about why one would think there shouldn't be exclusive licensing, it can be because of that, because you're giving a network an advantage in competition in a different market, not necessarily the market for the football itself, but for other markets. And so that's what would suggest that you want competition within the market, right? Within the market of soccer, not soccer, it's football here. Let's call it football. But when we have exclusivity, you can create competition for the market. So, you still get competition between the networks. It's just that now they're competing to have that one product. And I think, if you see, I think where Kaji landed was to regulate that competition and make sure that you don't get exclusivity for forever, but like you actually get it more frequently. And that is where I think competition authorities try to regulate that. If we're going to land in the world of competition for the market, to make sure that there is actual competition there. And then I think, as an economist, when I work on litigation cases, I always emphasize that things are very fact dependent. And it really evolves over time, right? So I think 20 years ago, you could think that if you start watching a certain channel, it's very unlikely that you're going to switch to another. But nowadays, I think we consume media in a completely different way. And, we can watch a game here and then a YouTube video there, and then watch some streaming, and then go back to the network to watch a sitcom or something. And so the media, the way in which we consume media and the way different media channels compete has changed a lot. So when trying to think about the trade-off between competing for the market and giving the teams and the league income in that way versus competition within the market and allowing networks not to have an anti-competitive edge in other parts of their broadcasting content, I think understanding that the economy changes and technology changes, I think that's really important. And then that brings me to the final question, which was like, we have different kinds of rights. And so again, we need to figure out the trade-offs there. So if you split, let's say, network or over-the-air rights from pay TV or from streaming or mobile for the same game, right? Again, you can create more competition. And, I think we all probably have our favorite announcers, and, we would rather watch a game with one announcer, or at least be guaranteed that we don't watch it from like the worst announcer, right? I think we all have those rankings in our mind. And so there can be a perceived benefit there. But then there can also be a benefit from combining them, right? Because if you think about, if you're going to send highlights from a match on your mobile, but you're going to watch the game on TV, there could be some cross channel effects there, where increasing demand for one channel increases the demand for the other. And when we see that kind of externalities, we usually tend to think that it makes sense to make the networks internalize those externalities, and that can be achieved by combining rights. Again, it's very fact specific. It's going to be different, across sports, across tournaments, but it's something to keep in mind when you're doing the analysis. And I think that fact specificity, really, you can see it in the fact that different countries have landed in different regimes. So in the United States, when I work, there's actually a statute that protects sports leagues right to license their broadcasting rights. In the UK, the Premier League has a very regimented regime where they have to split the rights into packages, and the same media company can't control too many of the packages. So they've landed in completely different ends of the spectrum, and I think it differs from country to country and from sport to sport. But ultimately, they're all trying to weigh the same, I think, benefits and costs of, on the one hand, recognizing that the league or the sport deserves to have income, and that it's a very important component of their income, and that is typically invested in creating a better sport. But on the other hand, that there are many other aspects of competition between the broadcasters that could benefit consumers. And so you have to kind of weigh those pros and cons.
Okay, thank you, Maria. Now let's talk about sports betting. Recently, news about soccer players involved in match fixing to allegedly manipulate betting systems stirred public debate. This is a billionaire market, and it's highly concentrated and largely unregulated. But there are ongoing initiatives such as the Fair Game in England, that is an alliance of clubs dedicated to promoting governance development in soccer, which has led to the establishment of specific regulations for this market. And here in Brazil, we have a regulation coming up of gambling in Brazil, especially sports betting, soccer matches. And so, Mariana, what are the impacts of sports betting on sports law, and how do they shape the landscape of the industry in terms of competition, integrity, and transparency?
So at first, I would excuse myself for my English, and also I'm going to switch to Portuguese to thank you. Então, muito obrigada, Jéssica, pelo convite. Obrigada à instituição pelo evento. Parabéns. Está muito bem organizado, muito bacana. Só ouvi elogios até aqui dos painéis. And going back to English. So I have made some bullet points here, so I don't get lost with myself with my English. But I'm going to try to show you some points. So at first, I would like to bring up a background of myself. I used to work as a criminal lawyer for 10 years, and then 5 years ago, a betting company searched the practice which I work at, and asked us, "Oh, okay, we would like to sponsor a football club in Brazil. Can we?" And then I started looking at this market, and then my career went through a totally different line. And nowadays I work as a sports lawyer, and I'm living the dream of working with football. But actually now I like football less than I used to like. But okay, going on. So the sports betting market here in Brazil is really huge. It has grown for the last years, and the Brazilian government was losing taxes and informal employees. So, just for you to know this, the betting companies that we see on TV, like Bet365, PixBet, and all of these, which sponsors many football teams here in Brazil, they're not here in Brazil. Actually, they are in other countries such as Malta, Gibraltar, Curaçao, England. So Brazilian government looked at it, and by the end of 2018, there was this law 13756, and it had 4 years to be regulated, and it wasn't done for political reasons. And as the government changed by the middle of July, maybe July 5th, finally we had a provisional measure that established some rules concerning to sports betting here in Brazil. So this law, this provisional measure that will or not become a law on the next 120 days, provides some regulations on taxes and on other subjects, and there are going to be new regulations over publicity, advertising, financial transactions, and sports integrity. In the beginning of this year, it exploded in the media, the Operation Penalidade Máxima, so maximum penalty maybe. I used it to work with Lava Jato.
Recording in progress.
And it was very funny to say car wash operation. Now we have a maximum penalty operation here in Brazil. That exploded that. Many clubs here in Brazil, actually many athletes, were involved into a match fixing scheme. Match fixing is a really, really hard problem to be settled. Studies, there is an organization, there is actually an arm of Interpol which just takes care of it. So the international police is looking at it for the last maybe 20 years. And here in Brazil we had other scandals such as Máfia do Apito and the Máfia da Loteria Esportiva in the early 80s. But now this operation penalty, maximum penalty, settled the lights to this problem. And what is this problem? The problem is that the major problem in this is that scandals like this makes the competitions to lose credibility. And which are the consequences of it? As the competitions lose credibility, the watchers, so the supporters of the teams, they lose interest in the sport. So if football nowadays is $1 billion market in all over the world, and it is so valuable because people like it and people encourage their teams. If people lose interest into their teams, if the clubs loses and if the competitions lose their audiences and their supporters, there will be no rights to be sold. There will be no interest. The audience is lost. So supporters and fans lose of it. And if they lose their faith and their passion, there are many negative consequences. The number decreases, clubs disband, there is broadcasting loss of interests. So it's a really huge problem. So many things are being made to protect sport integrity. Generally, I repeat this in Portuguese many times, and it's hard for me to repeat it in English. But I used to say that the imprevisibility, so the unpredictability of sports, is what makes sports different from any other kind of entertainment. It's really different. If you go to the movies and you watch a movie, maybe at some point you know what happened in the end. Sports, you don't. Some aficionados like me, I like to watch some previous matches from other World Cups and other matches from my team, the team that I support, that I can say now publicly. It's one of the bad things of working with soccer. But I like it. But we know what's happening in the end. So unpredictability is what makes sports different. If you take it out, sports loses its main essence. So the protection of integrity is as huge as is as important as the existence of the sport itself. So going on, this provisional measure, it provides some mechanisms to prevent match fixing to happen. So it gives the betting operators the obligation to provide some systems which are digital softwares that work to monitor the market. Actually, I work as a prosecutor for justice, for sports justice for Federação Paulista de Futebol. And there we have previously we had Sport Radar as a company, and now we have SPI as a company that they monitor the market. So at first they collect the odds and they check if there are any strange movementations, if there is any strange moves there. And if it's there, some experts, which are integrity officers, they look at the broadcast of the match, and they look at the behavior of the athletes, and they check out. So the regulations of betting in Brazil, it's very important to prevent it. And it's very important to give the light to the problem and to look at it as it's serious it is. So I think these are my initial considerations. If you have any questions after, I can answer them.
Okay, thank you, Mariana, very much. Now moving to an international hot topic regarding antitrust and sports, the merger of PGA Tour and PIF. So PGA Tour is the main league of professional golfers, and PIF is the Saudi Arabia's public investment fund that created Live Golf, a new professional golf league. And Live Golf and PGA Tour have been involved in an ongoing antitrust lawsuit since last year, and now the two rivals are holding hands. While the PGA Tour held for decades a monopoly position over professional golf, this deal would establish a new dominant group with complete control over an industry that only recently gained a competitor. So, Luciana, this merger certainly has important antitrust concerns. And what is your view on this merger and the previous litigation? And what do you think will be the outcome of this case?
Well, good evening, everybody. It's a pleasure being here today. Thank you, Women in Antitrust, for the invitation. I'm very happy to be part of this amazing network of women that has been growing each year more and more and more. And Jessica, thank you for having me on the panel. Before discussing this case that is very interesting, it's almost a funny case, I'd like to make some comments on the importance for us to discuss antitrust and sports here in Brazil. Well, as everybody knows, sports, and mainly football, plays a major role here in our country. It's probably nowadays, and unfortunately, one of the single reasons of nationalism for us. And we have a lot of people relying on football to have a chance of better lives. And it can be for us a tool of social development. So that's why it's so important for us in this beginning of organization and regulation of the market to take care on how these markets will be grown and will be developed within the next 2 days. So that's why we have Kaja here today. So getting back to the case, when I started studying international case law to represent clients in CADE, I had the privilege of working in 2 of the major cases already reviewed by CADE. Diogo will be the pleasure to talk about them soon. Our law firm represented the investors in the purchase of Botafogo and Vasco da Gama. And when I was studying for these cases, I realized how rich the case law abroad is. And comparing the studies that we have in Europe and in the US with the studies and with the case law we have in Brazil, we see that we are like way behind. But of course, our infrastructure of markets are pretty much different. And I started wondering how and when Brazil will be able to reach such efficiency. So I guess it's a very good moment for us to start developing, creating a good critical base for the future cases that are surely to come. So getting back to PGA Tour case, it's again a very funny case. As Jessica has just told us, PGA Tour, it is the name for who is not familiar with the acronym. PGA Tour is the name of the organization for the golf tournament in the US. And it is the only tour that we had in the US for the past century, not only decades, but century indeed. And in the last 2 years, a new competitor from Saudi Arabia named Live Tour entered the market to compete against the PGA Tour. As you know, golf is a very fancy, it's a very luxury sport. Only very rich people are able to indeed be part of this reality. And as you know, too, the Saudi Arabian government is very rich, and with their deep pocket started giving a lot of money for Live Tour to develop. And then Live Tour started luring the major golf players from PGA Tour, offering them like millions and millions and millions of dollars to attract them to the new championship. And in the end of the day, they could do this. A lot of very prestigious golfers started migrating their contracts and their exclusivity agreements to the new tournament. And of course, PGA Tour was not happy with this. And PGA Tour then started suspending the players who decided going to the new competition. And of course, as a result, Live Tour filed 2 antitrust lawsuits in the US against PGA Tour, stating that they were jeopardizing competition and, of course, trying to avoid the entrance of a new player. Well, the fight started, the 2 tours started criticizing one against each other in the media, and the players also become divided between the two competitions. Just for you to have an example, Tiger Woods, that is already retired, but is one of the most famous and prestigious players of golf, received an offer from Live Club to go to play there for 600 million pounds. And he refused, saying that it was not a classic golf tournament, that he didn't want to have his name attached to a government like the Arabian Saudi government that does not privilege human and women rights, and that he will not become a part of a club that makes Shakira in a concert together with the tournament, because this is what Live Tour did. In order to attract tourism to Saudi Arabia, they started inviting a lot of concerts and artists and so on to be part of the tours. Well, in the end of the day, after a lot of discussion and after a lot of fight in the American judiciary, both tours announced in the beginning of June a merger. So they decided to become one. So after announcing this merger, we can see, of course, that money always talks louder. The DOJ anticipated itself and issued a statement to the media saying that if the clubs decided to indeed merge each other, the DOJ would make a very rigorous analysis of the case, and that they will never accept some classical excuses that antitrust lawyers use, like the failing form argument. Well, the parties have not yet filed the merger control to DOJ FTC, so we don't know yet where the negotiation exactly is at this point. But we know that the American Senate is now collecting some hearings of the parties involved in the Senate because they are very concerned about the merger. And what are the main concerns? Well, first of all, the market of golf was very happy to start having two competitors instead of only one. And now they will have one again. So they will lose the only competitor that they had before the merger. And second, they are afraid that PGA Tour, as a non-profit organization, because it is, loses its sense of competing for sports, competing for making environment for the society better and to have people enjoying themselves in the tournaments and so on. And of course, PGA Tour will not be a non-profit organization after merging with this Saudi Arabian tour. So you asked me what I think about this merger. Well, DOJ knows better than I. Probably they will block the merger if it happens the way it was announced. But I guess they have some paths that they could make use of in order to avoid a merger blocking. For example, making some arrangements, maybe an agreement between them, setting dates for having two championships in the year. So we do not need to have a single player and a single championship. We could have both of them. And if they can do this in a way, of course they will probably be reviewed by the antitrust agency like attempt for cartelization, because they will divide the market, even temporarily they will divide to be able to prevail both at the same time. But they have some very economic good arguments to say that they will increase the demand, they will increase the consumers and the players' option, because if they don't require exclusivity from the players also will be able to play at the same time in the same year in the two tours. So it's a possibility. They could maybe hire Maria or LCA, Jessica, to try to make an arrangement and to file an associate agreement to the DOJ. I don't know. So this is the first case that I want to bring for you. It's very interesting. It's like a thing that is gaining momentum now. If you access the DOJ page today, you will see the hearings take place.
Recording in progress.
And that's it. Thank you, Jessica.
Thank you, Luciana. Now, moving on to SAFs. Brazilian soccer teams are historically constituted as sports association. However, there is a recent transforming regulation called SAF law. SAF, abbreviation for Soccer Public Company in Portuguese, is a new corporate framework that can be applied to sports clubs through a spin-off of soccer-related assets with a corporate management structure. And when the public company format is adopted, it allows the possibility of investors being shareholders and corporate controllers of soccer teams through the SAF. So, Diogo, the CADE decided to close the administrative gun-jumping investigations regarding the purchase of shares of Cruzeiro Esporte Clube, SAF, by Tara Sports Brasil from the R9 Group, and the purchase of shares of SAF Botafogo by Igor Holding. Could you explain these decisions and, in your view, what are the main challenges that lie ahead for CADE regarding SAFs?
Yeah. Well, first, I have to say that we closed the investigation because of the good job of Luciano here. No, I'm just kidding. I know that there are others in the audience that were involved in this agreement, so I'm not. I would try to not be unfair, but actually, we opened the investigations, the gun jump investigations, when we heard about the case of Botafogo and Cruzeiro. First Cruzeiro and then Botafogo and then Vasco, but in Vasco we decided to not open because we've already decided the two first ones. Try to set some stage for the future business regarding SAFs. SAFs is a new societary type in Brazil, so it's new for us. and the law of SAF it's a very important one regarding all the features that Luciana already mentioned about the importance of football, both for an economic reason and a cultural reason. So SAF, we look for the SAF's law with good eyes. With eyes, we are developing a new market, but also a new environment and a new environment that is good for Brazil at all. And then it gives us the idea to see how these agreements and how this business were made, in order to give a right signal or a precise signal to the society regarding the need for notification, the need for pre-notificate these operations to CADE. So I think the most important takeaways from these decisions is that the creation of SAF is not necessarily a case that should be notified to CADE. But once these entities start to sell shares and sell quotas to investors, then we are in a situation that if these companies met the requirements of and the thresholds of the law, you have to notify CADE, and CADE you're going to analyze these cases. And in both cases, both Cruzeiro and Botafogo, we decided that they were cases of concentration, but they are not notifiable because they didn't meet the requirements. They didn't meet the revenue threshold. So that's why we closed the investigation for gun jumping. But I see the SAF environment will bring complexity to the antitrust analysis, and also to will make us to have more in-depth discussions about antitrust and sports. I can foresee when many teams become SAFs that we probably will have some issues regarding labor, for example, and we have this example in other countries. For recently, the Portuguese Competition Authority have a case about no poaching regarding their league, and their league is not any more than a joint venture of SAFs. So SAFs in their law. So we believe that in the near future, all the SAFs and the clubs that decide to not become SAFs, but are also profit, not anymore non-profit associations, but profit entities, they will try to create some kinds of league or some kind of arrangements to negotiate the broadcasting rights and to organize together Brazilian Serie A and Serie B as a product, because it's a very profitable product and it has to be sold accordingly. So in these cases, we can foresee that maybe if the SAF has the same owner, or if many SAFs has shareholders that are common, or that has in some situations that one shareholder has players playing for another SAF. This kind of situation can create problems of coordination and collusion that has both economic and sportivity issues, and then we will have to go to more in-depth analysis to see if the economic aspect of the business is impacting the fairness of the game. So I think this is the future.
Okay, thank you, Diogo. And Mariana, why does the law not impose the obligation for all teams to establish SAFs? Are there advantages for the clubs to continue to be established under the traditional model? And do you believe that SAFs will make small clubs' life harder?
So many questions. So at first, we have to have in mind that the Olympics chart predicts something that it's predicted also as a principle in our Brazilian federal constitution, and it was repeated on Lei Pelé, and then it's now repeated on the sports general law that was recently published as well. So you can think that our lives are not so easy because there are so many new laws in the last 2 months. So, which is the autonomy of organization, so autonomy of sports entities, and which means that every sports entity, so federations, confederations, clubs, they are authorized to work as they want. Of course, following some rules, but they can organize themselves as they like to do. So traditionally, football teams here in Brazil, they were associations, civil associations. And huge teams are still associations, like Palmeiras, Flamengo, Corinthians, São Paulo. And they don't intend to become SAFs. So maintaining as associations, for example, allows the clubs to receive more lenient and different taxation in relation to companies and to SAFs. There are also, I don't know if you know this, but I would like to say, there are also some teams that are limitadas. I don't work with this nowadays. Limited companies. They are limited companies, and they are also SAs. For instance, Botafogo from Ribeirão Preto. It was an SA, and now it is a SAF. So this movement of small clubs becoming SAFs and big clubs become SAFs is happening. But most small clubs, they are choosing to become SAFs just for reorganizing their debits. During the last 35 years, football evolved as a business in Brazil. But these associations, they did not evolve it as well as a business. So there are no governance politics. There are no compliance rules in most of them. Actually, in the very most of them, even in the biggest ones. So it is kind of harder to work. But also, it brings up some advantages because there is no such fiscalizations. There are not many eyes on them. So all these factors made the operation of professional football departments more challenging to be conducted as civil associations. But the lack of finances, the lack of financial disarray, and also struggling with tax and labor procedures become their life very hard. So many small clubs are becoming SAFs just to do the execução unificada. Unified execution. I don't know how to translate this, but by this means they can divide the payment of these in many years. So it's an advantage, but it does not imply necessarily the entrance of an investor, as happened in Botafogo, Vasco, and Cruzeiro. But we can see, as it's happening with Botafogo these days, that a new way of organizing the institution brings up good results in field, because Botafogo didn't win a championship for the last maybe 20 years. And now it is in the first place in the most important championship here in Brazil. Also, the government's measures, they are being provided into the federations and confederations. That we're in a moment of mind changing in this. So here in Federação Paulista de Futebol, so São Paulo's Federation of Football, we have many departments and everything's really professionalized, but it is still a civil association, and it's always going to be because it cannot become a SAF. So this professional model can be repeated in clubs. And there are advantages of still being clubs, but new investors come into SAFs, and this organization of SAF may impact the Brazilian football as a general for the next years. I think it's a movement. And also, we're starting to hear about IPOs of SAFs. And can you imagine some Flamengo's opening stocks in stock market? Maybe there will going to be a bunch of money going into it. So it can affect the small clubs looking at this sense.
Okay, Mariana, thank you. And now I'd like to bring up the topic of antitrust immunity. Some argue that certain practices, such as salary caps or draft systems in team sports, are necessary for maintaining competitive balance. In the US, the restrictions on college athlete compensation are an example. So the NCAA is an organization that regulates student athletics and organizes their championships. And in June 2021, the Supreme Court ruled that the education-related benefit caps the NCAA imposed on student athletes were in violation of antitrust law. Now the students can monetize from the use of their name, image, and likeness. And Luciana, could you explain a little bit better the NCAA v. Alston and why this is a landmark case, the antitrust immunity surrounding sports in the U.S., and how do you differentiate between pro-competitive and anti-competitive practices in the sports context?
Well, this is a very, very hard and complex case. It took me at least 10 days to read all the articles to understand what happened, because it's like a mess. Not even the Supreme Court decision is clear. It's very complicated. I will try to explain. I hope I can prevail. Well, what NCAA is? It's the first question we need to know. NCAA stands for National Collegiate Athletic Association. It is the organization responsible in the U.S. to organize and regulate all university game sports. It regulates 24 types of sports, and it organizes annually 90 championships. So they are responsible for a lot of games. The amateur university games, they started being organized internally by the universities, and as they gained momentum in the past, they felt the necessity of being organized institutionally. That's why NCAA was created. That games that we see in our Sessão da Tarde, in that very fancy and nice movies, American movies, representing football players, beautiful and tan football players, playing rugby, playing football. Well, NCAA is responsible for organizing them. And in exchange for all the students' efforts to, of course, gain the championships and make money for the universities, because, of course, these games, they have the tickets sold to the market, they receive as a salary just the costs of the tuition and room. In accordance with NCAA regulation, the universities should pay for the students all costs related to education. So, of course, it's not only fees of tuition and room, right? We spend like laptops, conferences, we have to buy books. So there are a lot of things involved in educational costs that goes beyond what NCAA was offering for these students. Well, just for you to have an idea, NCAA, and it's public, if you find their website, you can download the financial statements in the last year. They made $1.1 billion US. So it's a lot of money. 90% of this revenue was obtained from television and marketing rights, and 10% obtained from tickets. They also pay for the coaches, because these games, of course, they are organized by the students, but the students are, in the end of the day, mastered by a coach. And the coaches are paid very well. Instead of the players, they receive like millions and millions of money. Just for you to have an idea, there is a very famous coach in the U.S. He belongs to University of Alabama, and he coaches the football championship of that university, the football team, and his salary is $11 million a year. He won already 7 national collegiate championships. So as you can see, it's a very, very profitable market for the coaches and for the universities, but not for the students. And in the end of the day, what happened? The students started complaining about these treatments, because, as you know, some of the students put their lives at risk when they are playing. Some of these games are indeed very violent. And they literally went to the courts saying to the NCAA, show me the money. So what happened? This name, NCAA versus Alstom and etc. Alstom is the surname of one of the students and etc. other students. So it's the plaintiffs represent a pool of former and current students against NCAA. And they open a class action lawsuit demanding, so it's a very, if you see the complexity of the case and you take a look at their requests, it's almost naive to imagine that they went to a lawsuit of this magnitude. And in the end of the lawsuit, they made a very little request because they requested for NCAA to pay just $6,000 per students per year since 2018. So it's a very little amount if, of course, we compare to the data I have just provided you with. So in accordance with the complaint, now I'm trying to explain the complaint of NCAA. They had the NCAA had the the complaint of Alstom. NCAA had the obligation of paying for all costs related to education. And they also stated, and here is the question of Jessica, a very strong antitrust argument to make their case robust. They said to the courts that by fixing the remuneration of the players as a pre-established and fixed price limited only to the tuition, they would be making a cartel in the workforce side of the market. Because, of course, they were, in the end of the day, uniforming one of the prices of the inputs of the product. And NCAA, in its response, defended that they could do it so because they were an amateur tournament and not a professional one, a non-profit organization. Non-profit organization which makes 1.1 billion per year, but a non-profit organization. So they should be granted with antitrust immunity and not reviewed at a normal player of the market. And they also stated that by providing access for these middle-class families who has the chance of going in the weekends to watch these games for a price that, of course, is very little when compared to the professional games, they would be opening the market for a new demand, a demand that would not exist if the amateurism games didn't exist. And they stated that if by any chance the court believed in Alstom's accusation of cartel, of price fixing, the court should multi-balance the anti-competitive effects of price fixing in the workforce side to the pro-competitive effects in the consumer side of creating a new demand. Well, Alstom, the plaintiff, replied to the defense, saying that amateurism was just a characteristic of the product, and not even no-profit organizations were exempted from the antitrust law. So this argument was not valid at all. And second, they told that the restriction of payments was not enough to say that it would not jeopardize competition, because they could pay the students a different price or different ways of payment, regardless the fact that they are professional or amateur. And also they stated that the case law that NCAA made use of for 50 times, they mentioned this case law 50 times in their defense, was invalid, because multi-balancing effects is possible only when you can compensate pro and anti-competitive and pro-competitive effects in the same side of the market, and not one in one side and the other in the other side. And NCAA did not make any proof of it. So in the beginning of June, the Supreme Court decided the case and unanimously decided to condemn NCAA to pay the $6 US dollars that the students were requiring for. And as it was not an antitrust case, because the core of the request was receiving compensation for the students and not making any CAA liable for antitrust infringement. But in the end of the day, when the court put their fundamentals to the sentence, they expressly told NCAA, pay attention, because you might be infringing antitrust laws. And just for having these statements in the middle of the decision, we had an immediately and practical effect arising from this case. Because right after the sentence was published, one of the major basketball student players closed a very good deal with a broadcasting company, selling its image for more than $1 million US dollars a year. So you can see the power of the enforcement, of the American enforcement through this decision, because the decision didn't condemn NCAA, but just for mention that they could be liable for an antitrust infringement, they right away gave up the restrictions and they started letting the players selling their image at least. So very interesting case. If you have the patience of reading 90 pages of the Supreme Court decision, I strongly recommend. Thank you.
Thank you, Luciana. And now, Maria, how do you see the legal challenges and calls for reevaluating this type of sports immunity, since sports competition represents a peculiar form of production?
Yeah, thanks. And first I need to apologize because I'm pretty sure before I said Luciana instead of Jessica, so I apologize. Thanks to Luciana too, but I meant Jessica for organizing. So I think that the economics, like this is the horizontal question that I was talking about earlier. And I think that my high level response to your question is I understand why there is an immunity, but I also understand why there are renewed calls to examine it, right? So let's start with why there might be an immunity. And I think we've all heard, Jessica, you were saying that it looks like teams collude sometimes, or like they're operating as cartels, right? And that is one of the reasons why we think this is an interesting question, because they do seem like they're cooperating while they're also competing. But I also heard, Mariana talk about how important it is to have integrity in a sport, or Luciana talking about the culture of the PGA and how it was important to maintain it. And so basically what we have here is we need to think about what is the product that is being produced, right? And so if you can think of matches, right? If you're thinking about football, the first thing you can think of is matches, and then you understand why that pela is about saying that the matches are produced jointly by the two teams. You could also think that there are tournaments. You don't just occasionally we watch friendlies or not so friendlies, right? One-off games that go across leagues, but most of us want to watch tournaments. So I don't want to think of the Copa Libertadores because my team recently lost in a terrible tiebreaker. But the Copa Libertadores is something we're interested in independently, or the national tournaments. And who is producing that when you think about tournaments is certainly teams. But also sometimes it's like the organization that puts the team that creates the tournament and that sets the rules, right? And then sometimes, especially in Europe, a lot of the antitrust law is about the organizing bodies, the ruling bodies of sports generally, right? So if you set a rule against betting or match fixing, or if you set a rule about anti-doping, or a rule about even all the rules that, how football has changed in the last 20 years just to make it more TV friendly, right? So penalty kickouts everywhere. I hate them, but like, you know, they happen, right? Or tiebreakers in tennis. There are ruling bodies that make the rules of the game and that sometimes create them just so that you're producing something that's more consumer friendly. And so essentially the question is, are these operating as cartels, or are they just jointly producing one product? And that is what brings us to what is the product, because if you think the product is the sport, then it does look like they're jointly producing it. But when you think about labor, right? The labor is an input into that product, and certainly it looks like the teams should compete for that labor, right? So that it isn't the organization that is getting the output of that labor, but that the players can be compensated fairly as well. And so in the US, the antitrust immunity, the first time it was enshrined in law was for Major League Baseball in 1922. And, you know, there are many reasons why it's not really relevant why it was given to it, because the economy has changed a lot since then. But also it has over time been chipped away at. And one of the main reasons it was chipped away through statute was for labor, because everyone understands that while it is true that you want to kind of preserve the spirit of sport, you want to make it something interesting, you may want to have to maintain the league to be competitive, which is why a draft may be necessary or a salary cap may be necessary. At the same time, you do want to have competition for labor. And so you want to allow players to decide which team they play for after their contract expires, for example, which was the example that led to the law in the United States that says, you know, there is no antitrust exemption for Major League Baseball in terms of labor. And so labor seems like a clear example where you can see how there is clear competition across the teams for labor. And it's harder to argue that you need to regulate that competition to promote, or you need to limit competition or just prevent antitrust scrutiny to promote the joint production of a good sport. We've talked about broadcasting rights, which is another case where there may be an interest in weighing pros and cons of allowing cooperation versus competition. And then you get into like a whole lot of other things that are kind of produced by the sport. Like, for example, in the NCAA case, the rights, the value of the rights to name, image, and likeness is a joint production, right? It's from the talent that the players have, but also from the investment that the NCAA makes in creating the sport. And to some extent, you know, it makes sense to me that the NCAA was arguing that you might want to weigh some pros and cons, because that's what we do when we see that there are trade-offs, right? Because if by investing in the players, you find out which ones are the ones who are going to become professional sports players and who are the ones who are going to try and get a normal job after college sports fame. And so to some extent, the league contributes to that, but obviously the athletes are the ones who are doing the hard work of training and competing and playing. And, you know, merchandising is another case where, you know, while you can see why there's a clear interest in having exclusive rights to broadcasting, it's less clear that every team should cooperate and collude and give their rights to create baseball hats to just one manufacturer, right? Like that is, so when you weigh the kind of the pros and cons of analyzing a market and applying antitrust scrutiny, just saying sports is kind of limited, right? Because we can see that there are arenas where there's clear joint production and you do want to enable cooperation. And if you let everyone compete, they might not reach the best outcome because you need some coordination. But then there are some products that are just products within sports, but are still, but are more traditional markets like labor. And so I think what I'm seeing in the United States right now is that technological growth, the growth of the value of these name, image, and likeness rights, and the multiple ways in which they can be licensed and sold has created interest in bringing in more antitrust scrutiny onto them. I mean, one of the cases related to Alstom, though not exactly Alstom, is about selling name, image, and likeness rights to electronic arts to create video games, right? And so that's why it's so important, is because you have video games, followers on Instagram or TikTok, right? You have way more direct contact between players and consumers, and that creates almost a new market, and that is what these players want to get antitrust scrutiny. And at the same time, I understand why the league is saying, well, we also help create that market, and we want to make sure that all the players, not just the popular players, can get their shot. And so there are competing interests, and that's when I think there can be interesting economic analysis based on the facts of each case.
Okay, thank you, Maria. And so thank you very much, Diogo, Maria, Mariana, Luciana. You certainly clarified several aspects of sports and antitrust. And I'm curious to see the development of all those topics and issues we discussed here today. And now we will open for questions from the audience. Are there any?
Oh, can you hear me? Yeah, okay. Oh yeah, that doesn't help. Sorry, Maria, I'm here on the very far side.
I hear you and I see you, so
thank you. So again, thank you very much for all the panelists for the contributions. I think this discussion is important not only because, I mean, when we're in an event about women in antitrust, sports is like a very male-dominated topic. So I think that's also one of the reasons why we wanted to have the panel. But I see from the discussions that you brought about that to some extent we see jurisdictions in which the debate is very much developed, if I could say that. Like maybe in the US, we have a lot more discussion about this. In other jurisdictions such as Brazil and perhaps Latin America more generally, in which the discussions are just starting right now. So I was wondering whether you see like any path forward for convergence within Latin America, which like what topics should we focus on in order to, broaden our knowledge and also propose more in-depth discussions about this issue in Latin America that, traditionally, at least in some sports, such as football, we had /have, there would be some debate here, but having Maria as an Argentinian and, World Cup winner, last World Cup winner, I think like we do have like prevalence in the sport itself. So it would make sense for us to also in the antitrust discussion about this. And I see that there's a lot of like divergence and room to grow. So I would like to know if you have any suggestions and any tips on that. Thank you.
Maria, the question is directed to you.
Oh, I was hoping it was not. No, it's a really interesting question. I frankly think, you know, when I obviously practice in the United States, I'm always really impressed because I follow I have a mailing list about all the kind of investigations and knowledge created by Kaji, and I get it from, I forget, I think from PAR. I get like international news, and I see Brazil in particular as creating a lot of interesting both case law and decisions and investigations, in part to state the obvious because it's such a big economy, right? So in comparison, I think it's very hard to get the same traction and the same level of depth in other South American competition authorities, not for lack of talent, but just basically because it takes the same amount of effort to create a good investigation of, you know, a national sports market, but it's the cost. So the costs are kind of the same, but the reach is greater in a place like Brazil. So I think what we need to probably do from national authorities is perhaps cooperate more across borders to create a deeper understanding of what competition challenges are being faced by sports organizations across the continent, just so that we can get that scale to make it to make the effort kind of pay off for whoever is paying for it. And so I think probably cooperation across competition authorities is what's going to allow us to really take a deep dive into this problems, because I'm sure that, you know, especially the labor considerations and the media rights considerations apply everywhere, right? Like the Disney Fox merger, I think every competition authority has to look at it. I think Fox Sports was a key issue in every country that I took a look at. In particular, it was an issue in Argentina. And so I think these issues, these questions are very relevant to our economies. It's just that we may need to pool resources to give them a good review.
Okay, any more questions? No? Okay, so to close, I'd like to thank again all the panelists and, of course, WIA for this opportunity and for making all of this happen. So that's it. Good afternoon to everyone.
Thank you.
Yeah, thank you very much. I learned a lot from everyone.